All right, welcome, commissioners. My name is Marissa Courtney, and today Micah and I will be presenting Panel L to you. We hope that you enjoy our presentation.
Thanks, Marissa, and welcome. So today our objectives are going to be, one, to describe Panel L. We recognize that it's a fairly new panel in relationship to Panel A and B. Just go over the differences between the panel as far as how it's used for licensing compared to the disciplinary. A review of the delegated authority that licensing has, just so everyone understands what decisions staff can make versus what the medical commissioners are making themselves. Possible outcomes from Panel L, and then the benefits of Panel L, and there's going to be a pitch at the end for your help with that. So as we move forward, let's just dig right in. So first, what is it? Panel L, to my mind, and I'm not going to read off this slide, but I'm going to paraphrase some things. You can feel free to read. Panel L, to my mind, is best described as CMT plus for licensing issues. And so with Panel L, you're considering initial licensing applications, not renewals. And your standard of proof for taking any sort of action or a burden of proof is lower. It's clear, cogent, convincing. It's preponderance of the evidence. And so what you typically see at Panel L are things like DUIs, other substance use, discipline in other states, malpractice that is concerning. And what has gotten those applications there is, one, a review by staff and determining that they have a concern about an application or they do not have the delegated authority to approve an application. They move it up to the medical consultant who reviews it and decides yes or no, this is within their delegated authority, or it's of a significant enough concern that it needs to go to Panel L and be reviewed. So Panel L will meet once monthly, sometimes twice a month, depending on the workload. And, it's again, initial applications, not the renewals, because once they have a license, even if it's expired, they have that property right that's been granted by the medical commission. And so if you have not had any sort of property right granted, then that's where the triggering of the different standards of our burden of proof gets going. And so, and then a typical application or a typical agenda packet is 3 to 8 licensing related cases. But we also have some one-off stuff that we talk about that's related to licensing and really about how to improve the process or how to make it more user-friendly. And so we'll get more into that as we move forward.
Thank you. So really the difference between what you've experienced with Panel A and Panel B is that you guys are focused on handling the disciplinary side of a person's license and are limited to the property rights that a licensee has. However, with Panel L, we focus on the license requirements laid out in RCW 18.71, 18.71A, 1871B, and associated rules. Some of the standards that we face are not clear. They are cogent and convincing. Why? Because there is no property rights yet. We haven't actually issued the license. We utilize the UDA RCW 1831 130 55 for our denials, and typically the panel reviews initial applications. We also review application language, standards, rules, and we also recommend considerations for policy. Like as of right now, we're looking at and trying to restructure our personal data questions in our application that have been submitted to policy for approval. What's policy? Application questions. What policy? Application questions, new licenses or profession types, like our new medical, MDCE license, our clinical experience license. We also have rules and policies like the USMLE testing, GME accreditation, exception waivers. That is something that is going to be brought to you guys in the next few months for your consideration and approval. and any IMG issues. Standards that would be brought forth would be either policy or rule, and consistency or transparency, and then of course the denial process, the BAPs, or any hearings. Yes, go ahead.
So Marissa, on those last ones, I do just want to jump in. With respect to consistency and transparency, we have been looking at a couple of items on that, and we will be working with Panel L to develop some standards. So one is that the common one that we see is DUIs. And how do you approach that? So basically the unwritten rule at this point is, and the rule is probably the wrong word, and I'm probably freaking Heather Carter out. But the way that the panel typically looks at it, and historically how the medical commission has operated, is if you have a DUI that I believe is 5 years or older, there's not much concern. If it's less than 5 years, we are going to want to send you to WPHP and get some kind of assessment to make sure you're okay before we move forward. The other side of that is a few years back we got a presentation from someone at Clear who pointed out all of the impacts a very early in life touch with the criminal justice system has on your ability to get an occupational or professional license, and is that warranted? And so that's one of the other standards that we want to look at for consistency and transparency, is just answer the question, is there a criminal conviction that without debate, without concern, we would be completely comfortable just flat out denying someone? We have the ability to, but should we is the question. And so looking at those specific convictions, are we okay with someone having a murder conviction in their past? Are we okay with manslaughter? Are we okay with kidnapping or something like that? And so just one, identifying those things, but then two, being transparent and putting those things out there to say very clearly to someone who would consider applying, here are our standards for consideration. If you have one of these convictions, we're being very upfront and saying, don't waste your time. We will deny based on the fact that this is in your record.
Thank you. All right, over the next few slides, I'll be discussing the delegation of signature authority, my staff versus the panel. With the licensing staff, there is two differences. We have either approval of initial licenses or reactivation applications and limited applications, or we also have the PA delegation agreements and now the MDCE delegation agreements that have been added to the licensing unit. They really focus under WAC 246-919-310 and WAC 246-919-070. Basically, my staff can handle any application that comes across our desk that have no positive answers. A positive data question answer would automatically make them a non-routine. And so that's something that we'll cover in our next couple of slides. Also, usually those personal data questions contain like out-of-state action or any negative comments, things that may come up in the application as well that need further review either by myself or the medical consultant. And then again, we pass it on to panel if it is out of our signature authority. So myself and Dr. Barrett and sometimes Dr. High are able to look at applications. Most of the ones that come across our desk are for applicants with medical conditions, minor traffic violations, malpractice, DUIs, like Micah had stated, prior to or over 5 years old. Those are typically handled by our medical consultants. There are some that I can look at, but of course we want to just stay within our signature authority. So we usually allow our medical consultant to look at that. And then the one that usually comes up most frequent is our span of more than 7 years to complete all steps of the USMLEs. If a applicant participates in a joint degree, so degree program. So that is something that comes across our desk pretty frequently. And then there's obviously other issues that may come up that need a higher view than my staff is able to approve. Now with panel, they actually have the opportunity of reviewing all the information that I stated previously in the licensing manager and medical consultant section. And then there's also cases where we have notice of decisions on applications and determination of a brief adjudicative proceedings. Something that is new that has come up that we have had panel L make decisions on are the compact requests. Those follow with the letter of qualifications. Typically, my staff will review it and make a recommendation for what the panel can do. So you're very educated on that. We don't let you walk in blindly for this. We at least provide you with here's what the rules are, here's what we need, and then you vote. So,
So just on that, Marissa, just to clarify the brief adjudicated proceedings piece. So just so everyone understands, you have a normal hearing that we see for discipline. We also have hearings for applications that are denied. They have a right for that. The brief adjudicated proceeding is where the facts are not in dispute. There is basically someone wanting a paper trial, for lack of a better term. Historically, we have not had too many of those, and usually how they're used in the health system's quality assurance is there's been a license that's been issued in error, and they have to pull that license back, and they want a quick process to do it. We have had our first BAP, to my knowledge, in over a decade, maybe more, just in the last couple of months. And that was over correct me if I'm wrong, Marissa, over an LOQ, or a letter of qualifications to enter the compact that was issued in error.
correct.
So the scenario was we issued it. It was pointed out to us by a sister state that the person did not actually qualify for the compact based on the compact rules, and at that point we had to pull the LOQ back, and this person lost their various licenses through the compact.
Mm-hmm.
And so Mike Farrell graciously volunteered to some degree to act as the presiding officer, so we can have staff act as that role. And so as we move more into the realm of compacts, we are going to see these probably more frequently used. The other piece on more frequently used is just the decisions to not simply issue a license. As Panel L has become more ingrained in how we do our business, we are seeing more scrutiny, really, respect to license applications and not letting folks through like I think we have in the past. So more denials, more withdrawals, that sort of thing, and I think they're appropriate. The panel really does take their job seriously. They get in needs quite a bit, and in these situations, it's necessary because it's not always straightforward. So with respect to the outcomes, as I said, they can Panel L can approve the license. They can request additional information, and they frequently do. It's not uncommon for a application to come back 2 or 3 times to a panel meeting because they're just not satisfied with the information that's been given. And I will always encourage them to do that. We can place the application on hold pending the outcome of something in another state is usually why that happens. So if someone has an investigation or something that's supposed to go to a hearing in another state, we will place the application on hold, notify the applicant that that's what we're doing, and they need to let us know when everything's resolved in the other state. Another common one is the Notice of Required Examination, or NRE. This is most common applied to, this is how we refer people to WPHP or other groups. And then finally, Notice of a Decision, which is either a denial or a stipulation of practice. So it's a non-disciplinary practice condition. Maybe they have to complete a certain training. Maybe they need some oversight. Maybe they're not allowed to prescribe, something like that. But it's basically, we will give you the license, but. And usually there's some level of oversight on that. And typically we don't actually have them, as far as I know, appear at compliance. That's usually not part of the stipulation. So, and then finally, this is a new one for us, and we're actually getting this added into the DOH, I believe, Administrative Procedures rules, is the letter of qualification of ineligibility, and that's related to the compact, and where we say you did not meet the qualifications to the compact, so therefore we're saying you are ineligible. And it's a privilege, it's a denial, and attached to that are hearing rights. And typically what we're encouraging people to do is go through the brief adjudicative proceeding process if they want to challenge that.
Perfect. All right, so benefits of joining panel. You learn about the licensing process and you gain a complete understanding of what really goes on in reviewing non-routine applications. You get an in-depth conversation with your fellow panel members about applications that may change your perspective on certain scenarios. I know that that happens almost monthly. There are situations that come up where we may have gone into a panel saying, no panel is going to deny this, and then they talk about it and then they come up with different perspectives and they see it from a different point of view than myself as the manager or even some fellow doctors. So it's very interesting. You get that your voice actually gets heard in this, and you get to review something different literally every meeting. There may be some things where you review a case again, like Micah had mentioned, where we may present something back after we get new information. But most of the time there are different circumstances and every application is unique and different. You can help create policy related to the positive side of working of the work that licensing does. And we definitely are thinking about like matching sweatshirts and keychains and jackets. I mean, we we want to make sure that
Solidarity.
exactly that panel is effective and fun at the same time. As we understand that these are complex cases and they do take time, but there are some huge benefits to being a part of something that's special, something that's different. So if
Right.
you are did you
So
want to add
on
to
that,
that? Yes.
yeah, so on that, the reason we're making this pitch is because we do have commissioners who are panel L currently and have served great terms on there, but their terms on the commission are coming to an end. And so we do need folks to consider signing up for panel L to volunteer for that. As you know, the commitment is once, maybe twice per month. It's not a huge onslaught of applications, but it's
Mhm.
between 4 and 8 per meeting. But it is an important thing. It's as Melanie has said, licensing is the commission's bread and butter. It's the first thing we do, and it is what brings in the money and what gets the most attention on the policy side if we do it wrong. So that's the reason we're making an appeal, just to let everybody know there are vacancies coming up. So if you are interested, please speak with Chair Malden. He is the one that can do the appointments to there. We're happy to have folks, if they're interested or want to see how it works, to sit in and observe a meeting to see if it's their cup of tea or not. But bottom line, we're gonna need at least 4 to 5 folks to fill in, and we're happy to have alternates.
Yeah.
And to answer one question, why do we need to have a separate panel for licensing? And really what it comes down to is the licensing mindset versus the discipline mindset is simply different. There is expertise and knowledge that you have to work through and work with on the licensing side that is not always applicable to the enforcement side. So the solutions that we have to craft to deal with licensing applications tend to be different and fairly unique compared to what exists in the panel A, panel B disciplinary world. So that's really where it comes down to. Also, there are formalized decisions that have to be made by a group of 3 or more commissioners, and so that's the other reason to formalize that process and make sure that we have some standardization and defensibility to our process. And with that, I believe we are wrapped up with our information. If there's any questions, we're happy to take those, if that's allowable, Amelia.
Sure. I'm going to unmute everyone so that if anyone has a question, they are free to speak.
Perfect.
So this is
Scott.
Alden.
Oh, go ahead.
one of the principal differences in panel L is that every panelist reviews every single case. So everybody comes to the panel with the same body of information, and it's actually remarkably different from panel A and panel B. If a person gets a license, it is much more difficult to remove that license than it is to keep them from getting a license.
Right.
And so there are a number of mechanisms that we have us to use that we try and get it right the first time.
Okay.
I absolutely agree. And one example that I can give that involved Dr. Roberts specifically was an application that came from obviously out of state, and he just read in, and with his experience as a CMO, that something was not right with what we were being told. And this is one of those examples where going back and asking for more information repeatedly, because we knew exactly the information, he knew exactly the information that we needed to make the decision, resulted in ultimately probably the best decision to be made to protect the public in that case. So you do review all of the applications. You do bring your own expertise, and I feel like everyone on panel really does bring an essential piece of knowledge to help make an informed decision.
Definitely.
Also, as with any other panel, the members that are not physicians are essential. It is really important from the public member point of view in this panel.
For that, I will call out Ms. Blake and Mr. Malden. Their professional experience has been enlightening in the licensing side, because it's good to understand just from the credentialing side of things. It's like, no, we wouldn't credential this person. I'm not sure why you would license them. That's a really helpful comment. The other side is, Mr. Malden's, Chair Malden's malpractice background and understanding risk management. It's so insightful, because when we look at these NPD reports, they are not incredibly detailed with respect to malpractice reports, but he kind of gets his witching rod out and divines out what the truth is.
Yeah, I always liken this to my past experience of working in the insurance industry way back. It's almost like an underwriting decision. You're looking at the qualifications of whether or not you want to accept an individual or not, and it's just very similar. Just look at qualifications, look for what the background is of an individual, and it's like either you're qualified or you're not to be licensed in the state of Washington.
Right.
If I was interested, because I am, in getting a little more information and attending some of the meetings to learn more about this panel, that sounds extremely interesting. Is voicing my interest good enough, or do you really want an email that documents it?
I'm sorry, it doesn't show your name when you're talking. Who am I speaking
Okay.
with? And I'd be happy to connect with you.
Yeah, you're speaking with Arlene, new
Hi,
panel
Arlene.
member to panel B.
Perfect. Nice to meet you. Yes, we actually have a panel coming up on December 2nd. We usually have panel on a Thursday at noon. I don't know if that works for your schedule, but I would be happy to connect with you after this meeting and get you more information and answer any questions that you have. And we can have you sit in and observe a couple of panels if you're interested.
Thank you. I very much appreciate that. I'll be sending you an email.
Thank you.
Also, it'd be really good to have a PA on this panel. We would appreciate it.
I will take that.
Agreed.
Go ahead, Dr. Lyle. She unraised her hand.
Oh.
Does anyone else have a question?
Any other question?
Scott Rogers had a question. He said, if we volunteer for panel L, would we have to wear the matching jackets?
Well, I
I
mean,
think
there
that
is a dress code, so I mean, we have to apply that equally.
right.
The 2022 edition is hot pink, so I mean, so just make sure that that matches your coloring.
I mean, it'll have gold piping and everything. It'll be tasteful, very tasteful. Does anyone else have any questions?
Hanling has her hand up. And she has unmuted, but we can't hear you if you're trying to speak.
There's always the chat if folks want to put a question in there.
Mm-hmm.
Dr. Curry, go ahead.
I might have missed this because I was having trouble getting into the webinar, but did you say what triggers people to end up in panel L? Like if they're like there's automatic questions on their application that then trigger them to get further scrutiny? I'm sorry if you already said this, don't answer it. I will figure it out later.
No, you're fine. Typically, what triggers at least an applicant to become non-routine, to take a little bit more of a closer look at their application is if they mark yes to a personal data question, or if anything comes up on their FBI background check or their NPDB report. We do all of our reporting towards the beginning, and usually more times than none, an applicant is forthcoming with that information, and then it's typically flagged that myself or currently Dr. Barrett would review the application, and at that time, based on the comfort level and the level of I'd say difficulty, maybe not the right word, but depending on the circumstance, we have it reviewed by the panel just to get their perspective on the situation.
Okay, so that makes sense. I guess, and this is Diana Curry, by the way. And I guess what I'm wondering is 4 to 8 cases every 2 weeks or so doesn't sound like that many. And I would assume, given the number of people we license, there would be a lot more people who, have some kind of national practitioner database they report or check something on their application. So I was feeling like there had to have been a filtering system in there
Yes.
before it hits panel L. Okay, yeah.
Definitely. Yeah, and that is handled by myself and Dr. Barrett, which if Dr. Barrett's on this call, he's been doing a great job. We typically send him at least 4 or 5 applications to review daily that have something that's higher than my signature authority. And then at that time, it's really what he feels should go to panel, or even make recommendations that have to be approved by panel.
Got it. That makes more sense, 4 to 5 days.
Okay.
Okay, thank you so much.
I would like to add that 4 to 8 cases is plenty due to the amount of material you have to read to prepare for the meeting.
Yes.
I mean, you can read as many as 600, 800 pages of material in preparation. So it's, you don't want any more.
Oh, great. So now, John, you've made us all jump to want to do this.
It's
not always
packaged as
600
pretty.
pages. I mean,
No, it's not. No, and my staff has done a really great job of trying to pinpoint the main areas of concern, so it's easier for you to read. I personally, myself and my admin Emily, spend hours working on the panel packet every month. So we try to do our best to make sure that it's an easy packet for you to navigate. But yes, like Malden said, it is a lot to read. However, a lot of the cases that you're looking into are interesting, and I think that helps get through the number of pages that you may be presented, just depending on the volume for that month.
It
And,
takes
and
me
I would
about
have to add that
and Diana, it's really not all that much to read because it's redacted too. So
Yes.
It takes me about the same amount of time to prepare for Panel L as it does for a CMT.
That was my question, is what does the time requirement look like in comparison with CMT? Twice more?
It's about the same. It's about the
That's a
same.
good, yeah, that's a good analogy.
Mm-hmm.
It's also good to know. Thank you.
Yes.
And
And you
Yanling's,
receive, oh, go ahead.
sorry, Yanling's question is, what action does the panel normally take if an application fails to disclose a disciplinary action taken during residency?
Well, okay, so Marissa, do you want to jump back to that slide?
Sure.
Outcomes. So if I'm understanding the question, a disciplinary action taken during residency, I'm assuming that is going to be a regulatory action by a state board. And so if that's the case, we're going to learn about it through one or both ways of the National Practitioner Data Bank, as well as the Physician Data Center from FSMB will both tell us those things. And so we'll have notice of that. And my guess is usually when we have an issue where there's a non-disclosure, we do go back to the applicant and say, is there something you would like to tell us? And typically they'll fess up. Regulatory actions, I believe, are fairly uncommon for this scenario. It's normally I forgot that I got busted at 19 with a pot plant in my college closet, and I have an FBI hit that I forgot about. And usually, when they're told about that, they come clean and say, oh yeah, okay, no problem, I remember that now, and they get their records and they send it to us. Marissa, do you have a different take on regulatory actions?
Yan-Ling, the answer to your question is actually very complex. We virtually never get regulatory actions against residents, and that's a good thing. However, residencies do take actions against residents, and usually when we look at stuff, we'll see that it took them too long to finish a residency, or that they switched residencies in midway, and that's something we may have to request extra information about. Depending on what the thing was for, if they turned out that they just weren't good at surgery and they needed to go do anesthesia and they're great at anesthesia, different mindset, then there's no problem. And it shouldn't, the fact that they change in the middle shouldn't make any difference. If they went through 5 residencies in 5 different years, they don't actually qualify to get a license in this state, because you have to have two years of a residency in one place in order to be qualified. And that is a red flag that should be there, because that should set us on edge. So your question is not an easy question to answer. It's not they get a license or they don't if they had something which happened when they were a resident. But it is something that we know to look for and do look into.
Yeah, I completely agree. And typically the FSMB and AMA do a great job at verifying post-grad information. So typically if there's any disciplinary or any inclination that it was not a normal cut dry, they finished the program in 2 or 3 years, they will asterisk that AMA report, and that will trigger us to say, okay, we need more information. And then if a provider actually utilizes an FCVS packet, they do a deep dive into that program, and that allows the program to actually fill out a series of questions and explain what happened during that time. And they'll either tell us this provider was not above standard, or they were drinking on the job, or in the residency program. So they lay it out, and then typically the FSMB gives the applicant a chance to respond to those remarks. And so we have both the programs and the applicants, and then we also ask for a statement as well. So we try to get as much information for those types of situations prior to presenting it to panel. So you're at least having that information reviewed before possibly wanting more additional information, which you always can ask.
Okay, now Yanling says, thank you for answering my question. I meant those I think she means NPDB types, mostly actions taken by medical schools.
I think Dr. Roberts' comment covered that as well as Marissa's, especially with respect to AMA actions and FCDS. Any other questions?
There's none in the box. There's no hands raised.
Okay.
I'll just say this is super
Well,
helpful. I've been here for like 2.5 years and had no idea what Panel L did. Really, it was a black box. So thank you very much for doing this.
No problem.
We're trying to make it a non-black box at this point.
Yeah.
So there's, as I said, there's some policy efforts underway to try and increase transparency, even if that means drawing some hard red lines about what is allowable and what isn't upfront. So those are some future efforts that we will be working on, and certainly looking at what's in the qualifications for our rules for license application. GME was identified, the 24 months of a consecutive program was identified as a potential rule that needs revision. So that would certainly be one of those things that the Panel L would look at and recommend action to the commission in some way to take on rulemaking if that's warranted. All right, well, thank you everybody for your time and attention and your engagement during this presentation. And we'll hand it back over to Amelia.
Thank you, everyone. We did record this session, so if you would like to see that recording, you can reach out to me and I will let you know where it's posted.